Okay, guys, let's do part 2 of looking at this motion for fees in the Manson versus Gore case. Before we get started on it, let's go back to the East Coast in New York, because I haven't reported on this, although the Manson cases has done a great job of that. And that is the plaintiff there has conceded a good portion of Manson's statute of limitations argument. So people who were upset that Manson kind of caved on one of those for Ashley Walters in California will be excited to see the opposite happening in New York, where the plaintiff is going, yeah, these claims of when she was a minor, that the statute of limitations won't save those. So Manson is looking pretty good on a good portion of that lawsuit. Maybe we'll get into that later when the judge actually rules on it. So let's go back out to California and talk about the Manson versus Gore case. Now, remember this fee situation is all about the motion to strike, which is the anti-SLAPP motion. And that doesn't involve the whole case, because the defendants, Gore did not try to strike the whole case. They tried to strike the parts of it that they felt fell under the protection of the anti-SLAPP law. And that doesn't touch the swatting piece or the impersonating piece or the hacking piece. Those things are not part of this. So if Manson hadn't appealed, then, or neither side appealed, but in this case Manson, then this case would just proceed on the docket towards its resolution on the remaining claims. But of course Manson has appealed because he feels the trial court erred in striking the parts of the complaint that she did. And so the whole thing will be stayed while that's pending. But because the defendants won in large part on their motion to strike, that the judge agreed with them, they are entitled, okay, because the statute says they shall be awarded attorney's fees and cost. So they have to bring that before the court. They have to say, here's what we say the cost of fees and cost were for our work during this motion to strike. And they support it by talking about the attorneys and their education, their expertise, the billable things that they did, the activities, how they're reasonable for what was going on, the market rate in that area and stuff like that. Now, I did see comments from Wood's motion yesterday on the quick video I did of that, because I just skimmed over it, that seemed to think that it's unfair that Manson might be taxed with these costs, and I get that. I didn't really see anybody saying, well, the amount's unfair. And I kind of thought there'd be at least some reaction on that. So as Manson decides whether he agrees with this or not, and let's say he disagrees, he's got a few avenues to challenge this. And one, of course, is the appeal. And that's the primary one, because it gets to the merits of the thing. So Manson has said, I'm going to appeal this, filed a notice of appeal, but we don't know what his arguments are. So let's step off onto that for a second. If he were to file or move forward with his appeal and actually win it, that would moot this thing with attorney's fees, because the decision would be reversed and there wouldn't be a prevailing party on the defense side, so they wouldn't get these attorney's fees. So the appeal could save him on this, but more important in theory is whether it saves his case or not, right? And the appeal, you shouldn't expect surprises there, because what you're going to try and convince the Court of Appeals is that the trial court, the lower court, made a mistake that deserves reversing. And whether that happens or not depends on what kind of mistake you're alleging. So if it's a pure application of law, the Court of Appeals will look carefully at it. If it's something that's within the discretion of the judge or case management or something like that, they're going to look less closely at it. They'll say like, well, we might have done the same or we might have done differently, but that's within the realm of reason. We'll let that go. But things where it's a pure application of law, the Court of Appeals could look at it more closely. And the arguments you see from Manson really should be the same arguments that came up in front of the trial court, because it's not surprise time at the Court of Appeals. You don't get to bring up things that you didn't bring up to the trial court. So you can't bring up some new evidence or a whole new legal theory or something like that, because those things wouldn't be mistakes by the trial court. That would be your mistake for not doing it in the first place. So I don't think we'll see surprises there. We're going to see the arguments that he made to the trial court fleshed out differently, because this is an appeal situation and you have to put it in that kind of posture. But still, we know what the arguments are going to be. That, hey, the FBI letter claim that letter is not protected, so it shouldn't even come under the first prong of this anti-SLAPP thing. And then even if it did, you still shouldn't have thrown it out, and the other things that have all been argued and decided by the judge. The Court of Appeals will take that up and Manson will make his arguments again. So we'll see some of that. Now, if he loses the appeal, however, that's not good news for the case, but it's also not good news for this whole fee thing, because you're likely going to be taxed with the cost of the defendants having to defend the appeal, and they'll file a new or modified motion for fees, and they'll include all their appeal costs as well as the time it takes to enhance their motion to include those. So that can get very expensive. If you're thinking it's economic so far, it's going to tilt toward the expensive side if that were to happen. So there's, a decision to be made there about this, but I guess he's already made it because he's noticed his appeal, and that's fine. Now, it's not just the appeal as a measure of defense or a way to defend against this. If Manson thinks, well, the rate they're charging is too high, or the activities or amount of time for the activities are not fair or reasonable for what they say they did, then Manson can argue that at the trial court. And he can say, hey, judge, they're charging $100 an hour too much. Look at this area average or whatever. Or can you believe, why would they charge 100 hours just to write this 5-page brief, Your Honor? That's totally unfair. Everybody knows you could do that in 10 hours. So those kind of arguments happen in, fee arguments all around the country. So he may do some of that, and the judge may cut down the fees a little bit. Who knows? It's up to her. Now, if Manson doesn't like that decision, he could appeal that same situation. It's going up to the Court of Appeals, and if you don't win, you're just going to be paying more money. So it's not a good position to be in. You don't want to be in that position. But in California, the anti-SLAPP law is tilted to the defendant in this way. If the defendant wins, they shall be awarded attorney's fees. But if the plaintiff wins, then they only get it if you can show that the defendant filed a motion for some kind of delay purpose, or it was kind of frivolous or something like that. So the edge is definitely towards the defense. That's the way the law is set up in that state. So the judge has decided, of course, to strike material portions of Manson's complaint, and in doing that has said the defendants are the prevailing parties for purposes of the motion to strike. That's not a surprise, and therefore they're entitled to attorney's fees under the statute. That's not anybody's opinion. That's what the law says. So that's only going to not happen if the Court of Appeals reverses her decision, or the judge reduces the amount or something like that. So having said all that, we looked at Wood's motion yesterday in general, and now we'll look at Gore's. I did read some of the supporting paperwork. It's kind of what I thought, which is these are the things we did, the strategies we pursued. This is how we tried to be reasonable. Here's my educational background. Here's the background of the people that worked on the case. Here's a list of our activities. I'm not going to show all that stuff. It's a lot of pages, but I'll show this, what the argument is to the court, and that's what we'll go over now. Let me make that bigger. So we did it with Wood yesterday, and we'll do it with Gore now. All right, so here it is, and she sets hers for February of 2024 for hearing. All right. She's the prevailing defendant on a motion to strike. Now, remember, when I'm reading this stuff, I'm reading, obviously, her attorney's words. It's not necessarily my opinion one way or the other on any of these things, because Manson will probably have a response to this, and I'll read that too. But what we have right now is the position of her attorneys on cost, which they're correct to be moving for cost because they're entitled to it. How they say it is up to their own personalities. And let's see what they do. All right. She will and hereby does move the court for a mandatory award of her reasonable attorney's fees and costs totaling $204,483 and $2,500 in cost. So she's way under Wood, right? Wood was just under $400,000. So if you look at that, then you can say, well, look how efficient Illma Gore has been in this case, right? Her attorneys have done everything they could to be frugal in this case. And there's an element of fairness in that. I think they didn't run it up according to their own arguments, and some of that's persuasive. So let's take a look at it. They've got all these things here. All right, we'll go through the table of contents since we're going to actually look at this. And the cases, if you want to read those, you just go right ahead. But, and especially here where there's statutes and things, the law doesn't operate on anybody's opinion. It operates on the basis of the statutes and the cases. So you have to know those if you're going to argue in court, and they do, and they point them out here. But let's see how she frames this. I will have to say that Wood's attorneys took off Duncan pretty hard in their motion, and who can blame them? I know if you're pro Manson, you don't like it, but you can understand why they would do it. And then let's see what Gore's people do. After nearly a year of hard-fought litigation, she prevailed in striking plaintiff's defamation per se claim in its entirety, and in striking the primary focus of his intentional infliction of emotional distress claim under the Anti-SLAPP statute. And under the 425.16 Sub C, and the court's order, she's entitled to an award of attorney's fees and costs as a prevailing defendant. And that is true. It's not an opinion, it's true, unless this gets reversed. Costs of litigating the anti-SLAPP motion were significantly increased by plaintiff counsel's aggressive tactics. Plaintiff's attorneys filed dozens of voluminous documents, including 11 declarations, 2 ex parte applications, and a motion to lift the discovery stay. They also deposed Ms. Gore for information, submitted an extensive anti-SLAPP opposition. I repeat the word voluminous, evidentiary submission, prompting numerous evidentiary objections and subsequent meet and confer efforts to narrow the evidence and objections. Who can forget the judge saying, there's no way I'm going to sit here and rule on all these things. You guys work it out. Opposed Ms. Gore's motion to seal sensitive excerpts of her deposition that no party relied upon. More ex parte. Despite the extraordinary burden imposed on the parties and on the court, the challenge claims were found meritless and properly stricken by the court. Accordingly, she wants this $204,000 for 380.1, don't forget the 0.1, hours of her counsel's work on the anti-SLAPP motion, related litigation, fee motion, related court cost. The requested amount reflects the exercise of considerable billing judgment in efficiently staffing the case with only one primary partner and one primary associate, as well as voluntarily reduced portions of the actual time spent on litigating the anti-SLAPP motion and related task. I'm sure this will come up, but I'll just say it anyway since I'd read some of the supporting documents and it's in my mind. Their rates here are lower than the rates of the other attorneys in the case, I think, at least what the Woods attorneys said, and at least what they said King had previously requested in other cases. So that goes in their favor. They also billed at a discount, and the lead attorney wrote off sometimes for mentoring or administrative time or thinking about the case, as we used to call it, TAYC. And so she wrote off time and tried to be fair in terms of what she billed is what she has told the court, and it sounds reasonable to me. Again, she's at 60% of what Wood is charging, so she's not coming out of the gate with some crazy claim relative to her co-party. And in some cases, she did say that she drafted off of what Wood's attorneys were going to do or were doing to not repeat an effort. And that's, good when you can do it, and that's a good thing. All right. Facts and procedural history. Plaintiff filed the suit. Plaintiff's claims, Manson's claims against Ms. Gore targeted her work on an HBO documentary called Phoenix Rising and her support of numerous women who alleged they were physically and or emotionally abused by plaintiff. And that he alleged, of course, as we know, that she conspired with Wood to recruit, coordinate, and pressure women to make false accusations against Manson as part of the documentary, and that Gore slandered him. All right. Upon assessing the complaint relevant case law, her counsel determined that parts of it were subject to this anti-SLAPP procedure, the anti-SLAPP statute they mentioned here. They prepared it. They had to address various nuanced issues of law. And let me tell you, whether you're on the plaintiff's side or the defendant's side, that's a fair reading of what the law is out there. And nuanced can sometimes mean it can also be contradictory or it's just unclear sometimes what they're trying to get at. It's a complicated area of law, that's for sure. And if you wade into it, you have some work to do to really understand it. And you can't just guess at it, that's for sure. All right. Either side I'm talking about. And remember, this anti-SLAPP thing is supposed to be a quick way that's good for both parties to test whether the claims have merit, right? So it should be good for the defendant because they don't have to sit around accruing a lot of defense cost or time being involved in litigation they shouldn't be. And on the plaintiff side, if somebody brings this motion, it should be quickly dealt with. So if the case does have merit, you can move on with it and it's not just stopped in its tracks. But as the parties here have said, this motion's shut this case down for over a year and now it's going on appeal. So that'll be like a 2-year deal with this motion. It doesn't seem inexpensive and it doesn't seem quick. And as I did in a video a long time ago, I mentioned the judge's article that she wrote to the bar in general, just that these kind of motions often lead the cases to be slow and expensive. But she doesn't decide what the statutes are, and neither do we. It is what it is. All right, and then they talk about how this puppy got delayed so long. And then on May 8th, 2023, the court issued a tentative ruling granting substantially all of Ms. Gore's anti-SLAPP motion. And then it was adopted as final. That gave people on the internet time to argue that the tentative motion would be completely rewritten, but it wasn't. All right. And a couple of allegations were not struck as background, but generally speaking, the defendants won. Okay. And we know that. I know a lot of people disagree with it, and Manson does too. That's why he's appealing, but that's the current posture. All right. So they had to defend Gore in a deposition because the judge did grant a deposition of very limited scope. And Manson filed over 300 pages of documents to oppose the anti-SLAPP motion. So, they're saying this because they want to show, look, we had to read and deal with a lot of things. And they did. That's going to justify their fees, they think, which I get that. 9 declarations and 50 exhibits as supporting evidence. This motion's been pretty straightforward so far, right? It's not but so much dunking going on here. Maybe it's not her style. Although I think they did adopt the not move the needle theory earlier in a filing, a reply brief. All right. Let's keep it real and keep moving. 92. In response to hundreds of pages of documents that Manson put at issue, Gore submitted 92 evidentiary objections in her reply. So this is a lot, right? It's not a quick and easy motion, unfortunately. And the court ordered them to confer on it. They did. They had to argue about which parts of her deposition would be under seal. And then after briefing was submitted and evidence dispute streamlined, the plaintiff moved ex parte, just on his own, to add additional evidence that he did not include in his motion for discovery. So on February 23rd, 2023, nearly 1 year after filing his complaint, more than 6 months after discovery, he wanted to include another declaration from a non-party, forcing Ms. Gore's counsel to dedicate further time and effort in opposing the motion, which was, of course, denied. And, of course, who can forget that situation? Let's see. All right, so they say dealing with all this, they accrued a lot of attorney's fees. And they start talking about billing rates and $700, $755. But Miss Gore, I guess, got on Groupon or something. Maybe she's a veteran. For whatever reason, she got a discounted hourly rate of $602.14 for the partner's time. So that's a big discount, though. I know I'm being flippant a little bit, but it's material and it matters because it means that Gore ran up a lower fee amount and that they're asking Manson, therefore, for a lower fee amount. If otherwise, they'd be asking for this higher number. And that's potentially could be supported, right? Because they are asking for that wood and showing that Howard King has asked for similar numbers. So $600 is way under the other rate. And she led the development of the case strategy and actively managed the anti-SLAPP motion at all stages from its inception. And I think, even if you're on Manson's side on this, you have to recognize the success of the attorneys and the defendants, right? So if you're talking about whether they deserve fees or not, they handled complex litigation, dealt with skilled attorneys that Manson has, and ended up with a result for their clients that they wanted, which is striking a lot of the things out of the lawsuit. And therefore, they're going to be able to, unless the Court of Appeals reverse it, tax those costs over to Manson. So they're going to win this motion, or they did win this motion, and Manson has to pay his attorneys and the defendant's attorneys, subject to appeal. So pretty good result. If you're on the defense side, you got to like it. And then she talks about the rates that they're charging for the other people on down from $385 to $435. So that's pretty good compared to the other people. All right, she says, listen, I'm entitled to recover my attorney's fees because prevail on anti-SLAPP motion. That is true. They cite the statute again, and it says the defendant shall get these fees. It's not even a maybe. And you prevail if you consider to be successfully moves to strike a plaintiff's cause of action, even if it's just granted in part. And they won, almost everything here. So, yeah. Anti-SLAPP statute fee award provision is mandatory and imposes the litigation cost on the party seeking to chill the valid exercise of constitutional rights. And recoverable costs include attorney's fees and fees incurred in litigating the award of attorney's fees. So all the argument over the attorney's fees also increases attorney's fees, and it just goes down the rabbit hole. The court ruled that Ms. Gore is a prevailing party on her anti-SLAPP motion, which she won, and is entitled to attorney's fees. Yeah, and that happens because of that. She says, my fees are reasonable. And fee awards for successful anti-SLAPP motions are calculated using the lodestar method, which multiplies the number of hours reasonably expended, right, multiplied by the reasonable hourly rate. If it takes me 10 hours to read a case and understand it, but a normal attorney 2, I don't get the 10 hours, all right? I should get the 2, right? The lodestar figure, though, may be increased based on various factors. It's not limited to the rates actually charged or paid by the defendant. The court may rely on its own knowledge and experience, as the experienced trial judge is the best judge of the value of professional services rendered in her court. Can be adjusted upward. Interesting. Fee awards should be fully compensatory. It must be remembered that an award of attorney's fees is not a gift. It is just compensation for expenses actually incurred in vindicating a public right. Compensation should not be strictly limited to efforts that were demonstrably productive. Thinking about your case. All right. But she says, look, we pretty much did get what we wanted to get out of this. And, they didn't try and strike the whole lawsuit, just parts of it, and they were largely successful. And her successful motion has the practical benefit of narrowing the litigation. And therefore, of course, it's going to reduce fees on everybody's part going forward. It's a laudatory scenario because of the streamlined lawsuit. You won't have to do as much work in the future. The costs were more than reasonable. They have their declarations, verified time statements, reasonably directed to furthering the client's interest. Compensation is appropriate for every item of service which, at the time rendered, would have been undertaken by a reasonable and prudent lawyer to advance or protect his client's interest. And they do go over that in great detail in their declarations. It's very reasonable, they say. It was aggressive litigation. It was. Both sides worked hard on this. And she goes over again how much stuff that they had to deal with. Here she says, look, to avoid overlapping arguments and filings, Ms. Gore's counsel prepared and filed a short joinder to Defendant Wood's opposition to plaintiff's ex parte discovery motion. So that saved from doing original work there. But yet they still had to do all these things. We already talked about that. Blah, blah, blah. That's really just repeating what happened in the case. Throughout the 1 year that Ms. Gore's anti-SLAPP motion was pending and the flurry of related motion practice and discovery, her counsel spent 299.8 hours on the anti-SLAPP motion briefing and argument discovery and evidentiary issues. If there's one thing I hated about a large corporate private practice was having to count hours like that. And fortunately, I didn't have to do that for very many years before I went on to in-house and other things. And then they spent 80.3 hours for this fee motion. Then their rates are reasonable, by God. The skill for complex litigation, aggressive litigation posture by the other side. Now, she seeks an award of $204,000 at the standard rate she incurred, or the minimum $174,000 at discounted rates. Okay, so I guess they are saying, why don't you give us the full rate? But if not, how about this discounted rate? So, hey, look, if it's $174,000, then that is going to be roughly half of what Wood is asking for. So if you're Manson, you get to tip your hat to that and appreciate it. I'm sure his fans will appreciate Gore's efforts to keep the litigation cost to a minimum here. No reason to be a sore winner, right? And run it up. So either one of these numbers seems fair as they put it in this motion, and compared to everybody else's numbers, they would be. So So she said the total hours completely exceed the lodestar fees, $204,000, because they wrote off or did not bill about $19,000 in fees, didn't bill for time spent by staff related to the anti-SLAPP motion, even though potentially they could have. They carefully reviewed the bills to exclude time that was unrelated to the anti-SLAPP motion, which they should do. They did. And her fee request is comparable, indeed very reasonable in light of other anti-SLAPP fee awards. And they go over, some numbers have been handed out in various cases. Her fee request falls well within the range. Hyphen there. Well within the range of recent anti-SLAPP fees granted in Los Angeles and should be granted in full. Conclusion. Ms. Gore's counsel's efforts in protecting her First Amendment rights and securing early dismissal of plaintiff's meritless defamation and IIED claims should be fully compensated. So she wants this $204,000, or at a minimum $174,000. That is Gore's request for fees. So Manson will respond to this, I would assume, at some point, whatever the briefing schedule is there. I don't know exactly the procedure on this since he's already got a notice of appeal going, but whatever. And then we'll also see an appeal from him later on, an appeal brief if we can get a hold of it. But again, I don't think that'll have surprises in it. It should be the arguments advanced at the trial court and then advance to the appeals court as assignments of error and say, but here's where the trial court messed up and the standard of review you should apply. So that's what's happening out in California on these cases. They're looking at, somewhere close to $600,000 request by defendants for this motion for fees. So civil litigation is no easy walk to justice for either side of this case, or any case, really. It's a very imperfect way to get there. But it's bad news for Manson, but of course you knew that was coming if you were watching this case, because if you lose the motion to strike, then you're taxed with the cost and fees, and here they are asking for that, which is part of the process. And that's it for now, and we will see what happens later, and maybe check in on New York once the court issues an order there. Well, that's it. Thanks. Bye.